Welcome to the Law Offices of Jack Stevens webinar, Estate Planning Shockers. Your speaker for today's program is Jack Stevens, attorney, JD, LLM. Operator assistance is available at any time during this conference by pressing #. A question and answer session will follow the presentation. You may send chat questions at any time during the webinar using the chat window located to the right of the presentation. I will now turn the call over to our speaker. Jack, please begin.
Thank you very much, Michelle. And welcome, everyone, to our first ever webinar from the Law Offices of Jack Stevens. I'd like to say it's good to see you, but it's certainly not like the hotel settings that we're normally in. Just a few things. We're going to talk about some hypothets. There's materials available that you can download, and I'm going to stay basically within those hypothets, which have been designed basically from previous consultations and experiences that we have in the law office, just to alert you that there are things that present problems, but they are curable, and that's why we do estate planning. Before we get started, I had a couple requests. If you attended our seminar at the Marriott earlier earlier in the year, I told a story about a lady in Mississippi, and I've had several requests by clients to repeat that, and some who want to hear it. So I'm going to open with what's called When Grandma Goes to Court. Lawyers should never ask a Mississippi grandma a question if they aren't prepared for the answer. And it's something like this. The setting is a southern courtroom in Mississippi, magnolia trees all around, ceiling fans turning, people in the audience waving their handheld fans, a very hot, humid day, and Grandma takes the stand. In a trial in a southern small town, prosecuting attorney called his first witness, a grandmotherly, elderly woman, to the stand. He approached her and asked, "Mrs. Jones, do you know me?" She responded, "Why, yes, I know you, Mr. Williams. I've known you since you were a boy, and frankly, you've been a big disappointment to me. You lie, you cheat on your wife, and you manipulate people and talk about them behind their backs. You think you're a big shot when you haven't the brains to realize you'll never amount to anything more than a 2-bit paper pusher. Yes, I know you." The lawyer was stunned, not knowing what else to do. He pointed across the room and asked, "Mrs. Jones, do you know the defense attorney?" She again replied, "Well, yes, I do. I've known Mr. Bradley since he was a youngster, too. He's lazy, bigoted, he has a drinking problem. He can't build a normal relationship with anyone, and his law practice is one of the worst in the entire state. Not to mention he cheated on his wife with 3 different women. One of them was your wife. Yes, I know him." The defense attorney nearly fell out of his chair. The judge at that time asked both counselors to approach the bench, and in a very quiet voice said, "If either of you idiots ask her if she knows me, I'll send you both to the electric chair." And that is why you don't ask questions you don't know the answers to in trial. Anyway, everyone thought that was very amusing in a southern courtroom in Mississippi. All right, to the task at hand. Let's talk about these shockers. I want to begin with hypo number 1. This is somewhat uncommon, but it still happens, and we still see it. In this case, Brian inherited his mother's home in Del Mar. As a result of his mom's death, she had the home in her name, but she left it to Brian in a testamentary trust in her will. Now, Brian thinks everything is okay because it comes through a trust. and there would be no probate. The home was valued at $2.5 million and had a mortgage of $1.5, so there's equity of $1 million. The result is this: because the home is left in her will, it must go through probate, even though there's a trust in the will. It's called a testamentary trust. And this is something we certainly want to avoid. That's why we sign living trusts, otherwise known as inter vivos trusts, because they become active at the date we sign them. They have life at that time. A trust and a will is not initiated until a person dies, and then that will goes through probate. In San Diego County, it takes about a year and a half to go through the probate process. Now, that is not the only problem. The problem is when property goes through probate, and this is why so many people do trusts, execute trusts, living trusts I'm talking about. The property is assessed statutory probate fees. California is one of the few states left that has archaic probate with statutory fees. And in this case, the fees are assessed against the fair market value of the property. California does not allow debt to reduce the value of the property. So the home goes through probate at a value of $2.5 million, even though there's only $1 million in equity. Great reason to avoid California probate. So that is a lesson learned, and it's one we don't see often, but occasionally we will see it, especially people who have moved out of state. They had testamentary trusts in other states, and they feel like when they come to California they can leave their homes, etc., in a testamentary trust, which is included in a will. Unfortunately, that is a probatable asset. Now, I want to also follow up with something called Hegstad, in which we have been including in our documents for some time now. Hegstad, even though we have a property or bank accounts or stock or whatever that's left out of the probate process or out of the trust, that will go through the probate process. We see this a lot with refinancing. People take their homes out of the trust, refinance. No one tells them to put it back in the trust, at least from the escrow point of view, or the lender. So we have homes sitting outside the trust. With our Hegstad provisions that I've included in a number of clients' trusts for updating, and an updated schedule of assets that are attached to the trust, we can avoid probate even though the home or other assets are left out of the trust. The Hegstad I've filed, probably 6 or 7 petitions now, and asked the court to include the asset in the name of the trust because of the Hegstad decision successfully. And what that takes is a petition to the court. We go down on a hearing and get it done in a matter of weeks, as opposed to waiting out a full-blown probate of a year, year and a half in San Diego County, and probate fees. So if you've not done so, we would certainly want to update your trust with the Hegstad provisions and also update your schedules to your presently owned assets. They go together. Okay, let's take a look at hypo number 2, catastrophic catastrophe. I have written and I have spoken, if you've attended seminars and if you read my newsletters, I've written about the Deficit Reduction Act that is being implemented in California. That act is a health care act that has to do and has jurisdiction over assets when one enters a nursing facility in California. Basically, it preempts and precludes any more transfers of assets to qualify for Medi-Cal. So in this particular case, let's just take a look at the hypo with Carol and Ben. And as we know, we have many cases of blended families in California, or second marriages. And in this particular case, Carol and Ben were in a second marriage for 10 years, very close couple. They had separate property in their own names that they brought into the marriage, and they joined money and purchased a community property home valued at $600,000. Carol's separate property estate was mostly in stock that she had earned and inherited some over a period of time, and it valued about $500,000. Ben had some separate property valued at $200,000, for a total of $700,000 in separate property. But they designated it separately in their trust, and also they had a prenup that designated and they acknowledged between each other that they had a separate property estate. Neither had long-term care insurance. Unfortunately, Ben had a major stroke at age 65, the kind of stroke no one really wants to have, in the sense that he was disabled and for a long term, and as such was placed in a skilled nursing facility. Once that occurs, the couple is within the jurisdiction of another set of laws. And unbeknownst to many people, those laws, federal law, supersedes California community property and separate property laws. The Deficit Reduction Act, previously we had the MECA law that was enacted back in early 90s, 1990, 1991. Medicare Catastrophic Coverage Act, acronym MECA. The Deficit Reduction Act emphasizes that law even further, and this law continues in this way. It precludes transfers of assets, and it has a community spouse resource allowance, and we'll move it down here. Community spouse resource allowance of $109,560. Now let me explain what that is. That is an allowance. California used to have what is known as a California split. When a spouse went to a nursing facility, the spouses split the community property 50-50, and each spouse was awarded their own separate property, similar to if there was a divorce. In this particular case, though, if you look at the results, Deficit Reduction Act, Carol is assigned an allowance of countable assets. In her case, she gets $109,560. Ben is assigned the balance of the separate property countable assets of $591,440, which must be spent down before he is eligible for Medi-Cal. Notice that this spend down includes the wife's separate property. Even though they had a prenup, even though this is considered separate property under California state law, federal law supersedes. And there will be no benefits for Ben until that amount is spent down to $2,000 for him. So this is a major source of concern, obviously, among spouses, especially in second marriages. Well, it's a concern for any any spouses, traditional or second marriages or whatever, because uh, it can impoverish, obviously, the spouse at home if they are required to only keep $109,560, and if they're in their 60s and still healthy, how in the world are they going to live on that for the next 20, 25 years? So it's a considerable problem. And what we have done is to amend our trust and also to include transmutation agreements at the appropriate time to combat this law. The home also could be vulnerable because remember, it's a community property asset with both names on the home. If eventually Ben receives Medi-Cal, Medi-Cal can file a lien or claim for reimbursement against the home because it's a community property asset. So we use a specially designed trust for single people. If you are a single individual out there and you have this situation, we can transfer that home into what is known as a midget. That's an acronym. And I really don't have time to go into that particular type of trust, but it's a asset protection trust for the home. Now, getting back to this couple, as you can see, it is essential, and I would highly recommend that if you have friends or neighbors or family or whomever that has separate property assets in addition to community property, they need to know about this Deficit Reduction Act. It is in the implementation stage in California. It has not yet been completed, but we expect it to be completed certainly by the end of the year or early next year. But there are things that you can do. There are provisions that we put in the trust by agreement between the spouses as to transmutating property and putting it under the control of the non-ill spouse so that spouse is not impoverished. Okay, we're moving on. I'm going to speak, I said, for about 40 minutes. We'll open it up for questions for the last 20 minutes. And also you can send in chat questions during the webinar. The third hypothesis I want to discuss is very common, the IRA tax trap. In this case, Steve designates his son David as beneficiary of a $2 million IRA. That's a significant IRA. David is going to use that for his retirement and for his security in his elder years. In addition, Steve creates a living trust in which he transfers his home valued at $400,000 and other non-retirement accounts valued at $150,000. So he's got $550,000 in a trust and $2 million outside the trust in an IRA. He also signs powers of attorney created by a trust mill. We see these very often. I review numerous estate plans yearly, and I see these just cookie-cutter powers of attorney that are created. We see this over the Internet. And incidentally, what is it, the Zoom? You see on the Internet, Legal Zoom or whatever, they have been sued by several states for unauthorized practice of law. So I think Indiana just settled a suit with them. But these are the sort of things that you need to look out for and be aware of, because every state has different types of powers of attorney. One state may have laws that indicate you can include such powers in a power of attorney, and other states say no, that power of attorney cannot cover such authority or give such authority over a particular asset. But in this case, Steve has created this trust and powers of attorney with a trust mill. David is beneficiary of his father's entire estate, and as I said, intends that the IRA be utilized for his retirement. Steve loses capacity at age 70. Now, what does that tell us? Steve has to start taking minimum required distributions at age 70 and a half. How is that going to happen? David is his successor trustee in the trust, but the trust has no authority over an IRA. Why? Because the trust can't own an IRA by law. It's an individual retirement account. So, what is Steve going to do at this point? He goes to the power of attorney, as indicated by the authority of the power of attorney, and looks to see. There's no provision in there for him to make decisions on the IRA. So in this particular case, Schwab is requiring that Steve obtain a conservatorship to initiate the minimum required distributions for Steve beginning at age 70 and a half. If he doesn't, what is the penalty? 50% of the distribution that should have been taken. So, Steve hustles to a law office, gets a petition ready. He needs temporary orders as well as permanent orders. In other words, he's going through the rigmarole of going through a court proceeding to get the minimum required distribution for his dad, which could have easily been placed in the financial power of attorney and should have been there. But in many of them, there is no authority to do it. So, again, I want you to be aware that you should check your powers to make sure that your power of attorney addresses IRA and retirement accounts. If it doesn't, it needs to be updated or at least replaced. In that particular case, it cost him about $18,000 because he had to get the court orders, then he had to report, had accounting fees, had a continuing attorney fees for about 5 years. So something that should have been very simple cost him some money. Now, the real kicker was this. David, without any good, prudent advice from an attorney that's experienced in IRA funds, rolled the IRA into his name as an inherited IRA. When that occurred, a 1099 was issued indicating there was a distribution of the entire IRA in the year it was rolled over. Spouses can roll IRAs and put them in their name. Children cannot. It's an inherited IRA. The previous owner's name must remain on the account, listing the child as the beneficiary with that child's Social Security number. But I will tell you this, and I've seen it. I've had clients sit across the desk from me and say, I went in the bank and they said it was fine. I could roll it into my name. Why? Because banks don't give legal advice. They can't. They won't do it. If you want to do it, sure, they'll do it. They'll put it in your name. But I'm just cautioning you that if you have a significant IRA, you should use instructions and or the safest approach is an IRA designated beneficiary trust, which we create for clients, and we do this for numerous reasons. One, for this reason right here, to avoid because the trustee is the one that has the authority over the IRA, not the beneficiary, and we can control the distribution of the IRA out of the trust. We can also preserve it for asset protection in case a child is sued or is in a divorce proceeding or whatever, anything that creates legal proceedings and can jeopardize that IRA. So if you do have an IRA, you may want to consider a designated beneficiary trust for these purposes. All right, I want to move on to the fourth and final shocker. Now, look, if you think, I want you to go back. Look at that IRA. It valued it. It was $2.2 million at the time. Just think about the tax on that, the tax bracket that would be in. That's how much he lost in IRA funds in 1 year. Okay, let's move to hypo number 4. Hidden trust powers. I've written about this in previous articles and in my newsletter. They're called powers of appointment. Now, within this hypothet, we're going to go through it, and I'm going to mention some other issues that may affect you. These powers of attorney are basically in every trust. You just need to be aware of them. Joe and Janice in her second marriage with a blended family. Joe has 2 sons by prior marriage. Janice has 2 daughters. They create an AB trust for federal estate tax purposes. They have a $3 million joint account in which they agree each child is to receive an equal share of the estate on the death of the surviving spouse. That's the understanding. That's what they agree to. They're all for it. Da-da-da. The trust includes a general power of appointment over the survivor's trust. What does that mean? A general power of appointment means the survivor can appoint his or her trust to whomever they wish, to themselves, to their creditors, to their new boyfriend, their new girlfriend, to the kids if they want, to their cousins, anyone they want. That's a general power of appointment. You have total control with a general power of appointment to appoint it, but you have to take affirmative action and appoint it. Now, the trust also includes portability provisions for federal estate tax. What does that mean? Under our new law, we each have a $5 million exemption. That's to end December 31st, 2012, when we go back to $1 million each on our exemptions, unless Congress changes the law. Now, I'm going to say unless this Congress, I don't know if they're going to ever do anything together, and I'm beginning to doubt that anything's going to transpire between now and the end of 2012 because these people can't get along. They will not work for this government. I mean, for the government, for the good of the people that I'm seeing. It's like party line stuff. So this law is on the books, and you need to be aware of it. December 31st, 2012, the exemption drops from $5 million back to $1 million unless Congress acts. And that remains to be seen. But you need to be aware of that. And the reason that's important is because you need those AB provisions to preserve your exemptions. Because if the $5 million exemption goes away and we each have $1 million each, there could be some heavy estate tax. So we need to put flexibility in our trust, and we need to use portability. Portability allows the surviving spouse to transfer the exemption that's not used by the decedent spouse into his or her estate. So if we have $5 million each, we've got a $3 million joint estate. Okay, let's read on. On Joe's death, Janice, as the surviving trustee, splits the estate valued at $3 million in equal shares of $1.5 million each between the decedent's trust B and the survivor's trust A. She elects portability of Joe's remaining exemption. In order to do that, we have to file a estate tax return of 706 and elect portability. That means she transfers $3.5 million of his unused exemption into her estate, adding to her $5 million. Now she's got $8.5 million in exemption. The portability provisions only last until 2012 unless they're extended, and that's important. If the Congress extends it, Janice can have an abundance of exemption. Or, now listen to this, if the exemption drops to $1 million in January 1, 2013, and portability is continued, she would have 3.5 of Joe's exemption plus $1 million of her own, or a total of 4.5 million exemption if it's allowed. Remains to be seen, but what I'm telling you is if you don't do it, if you don't use portability, you could lose it and lose that opportunity in case that exemption drops from $5 million to $1 million. Now, in the amendments that we're doing for most clients, we have elected portability. We've had to amend the AB formula for that purpose. And we also put a provision in there that continues the trust as a survivor's trust if the exemption remains at $5 million, where we don't need to split up the AB trust. Okay, I've talked about some of those, but let's go back to this hidden trust power. Now look, Janice split this estate between the two trusts, $1.5 million in the decedent's trust, $1.5 in the survivor's trust. Continuing, during the 10-year remainder of her life, Janice uses the decedent's trust B, her deceased husband's trust, for her health maintenance and support, and that's typically provisions that allows her to invade that trust for those purposes unless they're removed or taken out. So she's living off the decedent's trust B and allowing her trust to continue to grow. Why? Take a look why. On Janice's death, the decedent's trust is valued at $600,000. Why is it diminished? Because she used it for her maintenance and support. And the survivor's trust is valued at $1.2 million. She used some of that, but it stayed relatively the same in value. Before her death, Janice exercised her general power of appointment in her survivor's trust, which became effective on her death to appoint the entire trust A in equal shares to her daughters. Okay, what are the results? After the death of both spouses, the A and B trusts are combined again. That's by the formula, and divided into 4 equal shares. That's what they said they wanted done when they, initially came into the office. There's $600,000 remaining in Trust B, but there's zero in Trust A because she's appointed it out to her two daughters. So we have a total of $600,000. So from the family trust, each child received an equal share of $150,000. However, the two daughters were appointed the survivor's trust. They received $600,000 each. As a result, the two daughters got $750,000 each, and each son got $150,000 of the estate. Clearly, it was not what the spouses agreed upon when they initially created the trust. This happens over and over again. Can it be prevented? Yes, it can. How? We can either put irrevocable trust provisions in on the death of the first spouse, which I don't recommend because it hamstrings the surviving spouse, and spouses don't like irrevocable trust provision where they can't change their trust. Or we can include a postnuptial agreement that we reference in the trust that bind the spouses not to unequalize the distributions to the children and basically preclude the exercise of the general powers of appointment. But there are other creative things that can be done. But you need to be aware that this can happen because under those hidden powers called general powers of appointment, the survivor can appoint that trustee to whomever he or she desires, and whatever's left in the trust is then divided for the children. Okay, I've talked for about 40 minutes now. These are just a few of the shockers people are amazed at, and when I say amazed, because I see their faces when I'm describing this, or to the children who are involved in a trust, or to that at-home spouse, community property spouse, when the husband, or vice versa, when the wife goes in long-term and I tell them, here's your allowance, this is the community spouse resource allowance, this is what you're allowed. So these are things that are fairly commonplace, but you rarely read about or see in the papers. At this point, Michelle, I'm going to open it up for some questions. Now listen, if you don't get your question answered, just email me, and we'll be following up with an email also tomorrow or early next week for you to, if you wish a consultation on any of these matters, or if you have interest in further topics, or if you have questions, you'll have that opportunity, and you can certainly email me any questions, and I'll get those answers to you. Michelle, I'll open it up for questions now.
Thank you, Jack. Ladies and gentlemen, for those of you who would like to ask a verbal question, please press 7# on your telephone now to be placed in queue in the order received. Again, 7# on your telephone to ask a verbal question, or continue to send chat questions. And as we wait for questions to come through, Jack, we do have a chat question that came from Pat, and Pat asked, Hypo 2 is the 591.5 of the combination of 600,000, 500,000, or 200,000?
It is the combination of 700,000. That's the separate property estate. What they do is they take the separate property estate of countable assets, which is the wife had 500,000, the husband had 200,000. So they take the total of 700,000, and out of that, the wife, the community spouse at home, is allowed an allowance of $109,560. The husband is allowed the remainder for spend down, $591,440.
We have another chat question from Elaine. Can an AB trust be modified to something like a dynasty trust?
That's no. The reason being, You can have certainly you can have provisions in for generation skipping, but typically a dynasty trust is an irrevocable trust in which we're transferring assets into the dynasty trust to get them out of the name of the owners, the trustors. They're doing it usually to reduce their estate. And in doing so, they can't own those assets any longer. In an AB trust, that's a grantor trust, that the trustors continue to own the assets in an AB trust. They can provide for grandchildren, but it's typically not a dynasty trust because dynasty trusts are usually arranged to transfer irrevocably assets into that trust.
All right, and we have another question from Larry. Larry asks, can an LLC be held within a trust?
Yes, the ownership of an LLC can be held within a trust, and that's fairly commonplace, and it's intended, of course, to keep any of those assets out of probate. An LLC usually is set up for asset protection, but it can be held by a trust. I will put a caveat there that depending on the intent of the LLC, I would bring in, as most of you know, I have 12 other attorneys. We meet twice a month, attorney roundtable, and we discuss issues like this. And I would certainly consult with my LLC attorney and coordinate with them. But the simple answer is an LLC interest, yes, may be owned by a trust.
We have a couple more questions on chat, and one of the questions asked from William. Jack, can you tell us some more about the Hagstad provision? And one, what are the provisions? And two, what kind of assets would you add to the schedule?
The Hagstad provision, what in that particular case, a piece of property was left outside the trust. The sons came in and argued, look, Dad intended, there's intentional language in the trust that he intended to own this asset as a trust asset, had it listed on a schedule and attached to the trust showing further intent, and the court agreed. He said, as long as there's that intent, and what we do in Hagstad, we quote Hagstad, cite the case, and fully state that the client intends to own this asset as a trust asset that's attached on Schedule A. And what is attached on Schedule A is usually the home, rental property, stock, bonds, all cash accounts, bank accounts, those sort of things that are typically owned by the trust. They should be updated and kept updated every year, and those schedules attached to the trust. IRAs have their own. Remember, any contract like an IRA or an annuity or a life insurance policy that designates a beneficiary is going to pass by that contract. Thus, it does not have to be part of the trust. And in fact, IRAs can't be owned by the trust. Life insurance can be owned by the trust. Annuities can be owned by the trust. IRAs and most retirement plans cannot. But if it's designating a beneficiary, it's a contract that designates it's going to pass by contract to that beneficiary. Thus, we're not concerned with probate on those assets. We list those on Schedule B, but on Schedule A, our trust assets, we want a full list of those assets, and the trust will reference that Schedule A with intent that they be a trust asset. Thus, if you leave one out, fail to put it in the name of the trust at the bank or at the investment company or because of refinancing, I can file a Hagstad petition and get a court order that it is a trust asset if we meet all the requirements I just indicated.
I have a couple of questions regarding the IRA. From Laura, as a surviving spouse, I have designated my 3 granddaughters as recipients of my husband's IRA. Can they transfer these funds to their own IRAs?
Okay, we need a little clarification. I have designated my 3 granddaughters as recipients of my husband's IRA. I'm assuming that the client rolled the husband's IRA into her name, which she has a right to do as a spouse. That's a rollover IRA. And yes, she can then designate her 3 granddaughters as the beneficiaries, which incidentally will allow the granddaughters to take IRA distributions over their individual life expectancies, which is a good deal because that life expectancy will allow those IRA funds to grow considerably. If those are, well, the granddaughters obviously would be much younger. They cannot transfer these funds into their own IRAs, and that's what an inherited IRA is. It's an inherited IRA, but you cannot change those funds into the names of the granddaughters. On the client's death, the granddaughters will keep the owner's name, Ms. Amick's name, on the IRA and add their names in separate accounts to the IRA and their Social Security numbers, but they, under no circumstances, can they transfer these funds into their own IRA. That's what happened, and that's in the hypothetical. That's why that guy got hit with tax in 1 year on a $2.2 million IRA.
And we have another question regarding the IRA from Mr. Tong. You mentioned a trust has no authority over IRA. Does this mean that we should not designate the trust as the beneficiary of the IRA?
Okay, now we've got to do some clarification here. You mentioned a trust, and it depends on the type of trust. A living trust should not be named under our present law as the beneficiary of the IRA, and I'll explain that here in a minute. However, a trust designed specifically for retirement funds and IRAs, called an IRA designated beneficiary trust, can be, because it's a qualified trust to receive distributions from IRAs over the lives of the beneficiaries of the trust. So it has to be specially designed. It's a separate trust from the living trust or the family trust. The IRS a few years ago made an argument in a tax court that said, look, if you make a living trust the beneficiary of the IRA, and those IRA funds are utilized to pay debts for the trust, taxes for the trust, etc., which normally any money coming into the trust, that's what they're used for. They're used to pay taxes, debts, and then distribute out to beneficiaries. The IRS argued, if you do that, you've made the trust a beneficiary of the IRA because it's benefiting. It's getting its debts paid. It's getting its taxes paid. And the tax court agreed. They said, you're right. The trust is a beneficiary. So what's the result of that? When you make a trust the beneficiary of an IRA for future distributions, they must be made over the shortest life expectancy of a beneficiary. If the trust is a beneficiary, it has 0 life expectancy. Thus, the IRA payable to the trust will be taxed in that year because there's no life expectancy to spread out. You could have children with 10, 20 years of life expectancy, grandchildren with 40, 50 years of life expectancy. Makes no difference. The trust has the shortest life expectancy because it's a beneficiary, and the IRS won those cases. Thus, there's no ability to pay those children or grandchildren, other beneficiaries of the trust, over their life expectancy. The trust is going to be a beneficiary. That's why we don't name a living trust the beneficiary of IRAs, because there's no way to spread those distributions over the period of the life expectancy of the individuals.
And we have a question from Sandy. Does portability continue beyond December 31st, 2012, even if Congress fails to act on exemptions prior to January 1st, 2013?
Under present law, what I've read, it does not. And that's from everything that I've seen. They can extend it. They may extend it, but under present law, it does not. My point being, okay, a spouse dies, you don't elect portability. The exemption drops, or the exemption goes from $5 million to $1 million, but they compromise, and that's what Congress usually is all about. We haven't seen much over the past couple of years, but they compromise, they drop the exemption, but they say, however, we will continue portability over the next 5 years or whatever the new law is going to be. But if you didn't elect it back when the spouse died on the 706, you've waived it. So that's why I'm saying we should put portability in our trust and elect it on the death of a spouse. If it doesn't continue, what have we lost? We just filed a 706 and just the cost of doing that. But if they do continue it, that gives more exemption for the surviving spouse. If this new law, if they drop it from $5 million, let's say they compromise it to $2 million, and they allow portability to continue, it just gives you more insurance of exemption against future federal estate tax.
Thank you, Jack. So far, that's all the questions we have on chat. Again, ladies and gentlemen, if you'd like to ask Jack a verbal question, please press 7# on your telephone now or continue to send chat questions. We have several minutes left on our webinar.
All right. Michelle?
Yes, sir.
I think if there's no further questions, we will conclude. And again, we ask for clients, if they have further email questions, send them to my email address, and we'll be sending out a follow-up email for those to respond and to give us some input on our webinar.
Great.
And thank everyone for listening, and we will be notifying you of the future webinars.
Thank you, Jack. Ladies and gentlemen, this concludes today's Law Offices of Jack Stevens webinar. Thank you all for attending.